Good morning, Venu.
Yeah, good morning. We can start.
Can start?
Yes.
Jatin sir, good morning. Good morning, dear members. Today we are here to discuss few concepts about first appeals under GST. I will share with you, with all the members present here, a few of my experiences working with Venkat sir and numerous discussions what I had with Jatin sir on several occasions. So first appeals under GST, we have to bear in mind that first appellate authority is a creature of statute who is empowered to review the orders of the adjudicating authority as to the legality and propriety of such order and to satisfy whether such an order passed by the adjudicating authority is legally valid and are correct or not. In the event the orders by the adjudicating authority are not legal or if they are invalid, there appears to be a scope for the first appellate authority to intervene with the adjudication proceedings what the adjudicating authority has concluded. He can even fill up the gaps what the adjudicating authority has left. He can even rectify the defects in the proceedings already concluded by the adjudicating authority in the event the order of the adjudicating authority is illegal or incorrect. He may undo the proceedings if the order is illegal or incorrect. The powers of first appellate authority is first at the stage of admission. The first appellate authority has powers even to reject the appeal even without admitting such appeals at the threshold or in the course of appeal proceedings, or may dispose the appeal without even considering the grounds that the appellant has preferred, unless it is impressed that the order of the adjudicating authority needs an intervention by first appellate authority, which will be discussed in detail in the following slides. We all know the provisions pertaining to the first appeals under section 107. Let us pay attention to few of the issues which we generally face while we prefer an appeal before the first appellate authority. Section 107 subsection 1 says that any person aggrieved by the order or decision of an adjudicating authority may prefer an appeal within 3 months. Now the issue here arises is what is the aggrieved person? Friends, let us pay attention to the words used in the statute, that it is the statute is using aggrieved person. So person is defined under section 2 subsection 84, and there is a taxable person and there is a registered person. So what does this mean? Whether an aggrieved person should necessarily be a taxable person or a registered person or a person on whom the orders have been passed. There is an order which is passed by an adjudicating authority on a certain person, say Mr. A. Whether Mr. B can file an appeal is the question. So aggrieved person, because of an order passed by an adjudicating authority, can be a person other than the person on whom the order is passed. The answer would be, according to me, yes. Let us attention is drawn to the orders passed under section 129, where the authorities at the time of intervening with the vehicles during the inspection in the course of movement of goods, the orders will be issued on the driver or the person in charge of the vehicle or the conveyance. In such a case, the person who is the consignor or consignee who is responsible to effect the movement of goods may prefer an appeal, because he would be the person who would be aggrieved by the orders passed by the inspecting authority. So the statute says that the time limit that has been, the statute specifies the time limit of 3 months from the date of communication of the order. So we all know that the date of communication is the date when the order is uploaded on the portal, GST portal. this is what the department generally, because of section 169, service of order is the date on which the order is uploaded on the portal. So 3 months plus 1 month extra time limit has been given, specified under the statute. But let us pay attention to the words again used in section 107 subsection 1, which says that the order should be communicated. While we refer to section 169, it says service of the order. If necessary, the title of the section says that service of notice, but the operating part of the provision says that service of order and notice or any communication. So service may not, when the statute is using communication can be understood of existence of an acknowledgement by the taxpayer. But whereas service, he may issue it and may be done with that service of the order. So the understanding here is, of course, we have an interim judgment by one of the high courts which says that the date on which the order has come to the attention of the taxpayer or the person is the date which should be considered to construe the 3 months time limit. There is a provision, 107 subsection 2 specifies that commissioner may by order direct any subordinate officer for departmental appeal. So commissioner may call for the adjudicating orders of the adjudicating authority and the adjudication proceedings to verify the legality and propriety. And in the event, if it appears that the order is invalid or the order is incorrect or the proceedings have been conducted in a manner that was not supposed to be conducted or not as per the provisions of the law, the commissioner will issue an order to a subordinate officer who can prefer an appeal against such an order. Section 107 subsection 4 says delay can be condoned for up to 1 month on sufficient cause being shown. Subsection 6 says that pre-deposit of 10% and payment of undisputed tax, interest and penalty, the balance amount of tax, interest and penalty deemed to be stayed. There are provisions relating to opportunity of being heard to be granted. Adjournment can be allowed up to 3 times. Additional grounds at the time of hearing may be allowed. This we will discuss in detail. Appellate authority to inquire and pass an order either confirming, modifying or annulling. Remanding is not allowed. We will discuss all of these points in detail in the coming slides. Section 115 says that in the event the appeal is allowed by the first appellate authority, the amount remitted towards pre-deposit shall be refunded to the appellant along with interest. Please bear in mind that is from the interest is applicable from the date of payment till the date of refund. Section 120 specifies that appeal not to be filed in certain cases. Section 120 subsection 1 under which the board may issue certain orders and instructions on the recommendation of the council, fixing certain monetary limits against which the orders may or may not have to be preferred by the department. Section 120 subsection 2 says non-filing of appeal by the officer will not preclude such officer from filing appeal or application in any other case involving same or similar issues. Contention that the 120 subsection 3 specifies that in the event the appeal is not preferred because of the board orders or instructions, the appellant or any other person who is willing to prefer an appeal cannot take the contention that the officer has acquiesced for the fact of not having preferred an appeal. In my view and in my understanding, there is no order or instruction as on today which specifies the monetary limits to prefer an appeal by the department. Section 121 specifies the appeals or the decisions which are not against which an appeal cannot be preferred. An order of the commissioner or the authority empowered to direct transfer of proceedings from one officer to another officer, or an order pertaining to the seizure or retention of books of accounts, register and other documents, or an order sanctioning prosecution under this act, or an order passed under section 80 relating to payment of tax and other installments. Such an orders cannot be challenged before the first appellate authority. So friends, now let's discuss about the scope of the first appellate authority. The first appellate authority can admit the appeal only if all the statutory requirements are met. Number one, limitation to file an appeal. Number two, pre-deposit. Number three, form and verification of appeal memo. Appeal filed after lapse of the statutory time limit specified under section 107 would be liable to be rejected at the threshold. We are all aware that there is a special procedure that has been specified via notification number 53, wherein an amnesty is granted to the orders passed prior to 31st March 2023 to prefer an appeal on payment of additional pre-deposit of 2.5% in cash. When it comes to pre-deposit, non-payment of pre-deposit also bars the first appellate authority to admit the appeal and reject the appeal at the threshold. Attention has to be paid to table number 14 and 15 of the appeal memo APL 01, wherein the appellant has to fill in the details of the tax that has been demanded on the appellant. Out of that total entire amount, how much is the tax that the appellant is disputing and how much is the amount which remains undisputed. We are also aware that pre-deposit can be remitted by utilizing the balance in the electronic credit ledger. We have Bombay High Court judgment in Oasis Reality. So form and verification of appeal may be after submission of an appeal. So we all know that as a procedure general practice, the appellate authority will accept the order, will issue the acknowledgement. That doesn't mean that the appeal is admitted. So once the appeal is accepted, the appeal papers and the grounds of appeal, including the statement of facts, will be reviewed in detail, and in the event if it is not forthcoming that there does not lie a scope for intervention by the first appellate authority, such an appeal will be rejected at the threshold without even issuing APL 02. In the event there are certain defects in the appeal memo, a deficiency memo will be issued asking the appellant to rectify the defects identified. And once such defects are cured, say for example, pre-deposit is not paid, or if there is no certified copy of the order which has not been enclosed with the appeal paper, the appellate authority may ask the appellant to rectify such defects. And once the defects are rectified, only then the appellate authority will issue APL 02 as an acknowledgement of having admitted the appeal. So 107(8), section 107(8) and 107(9) deals with the granting of time and adjournment of hearings. Admission of new grounds of appeal not specified in the grounds of appeal on the satisfaction that the omission was not willful or unreasonable. Section 107 subsection 10 says that any new grounds which is not forming part of the original grounds of appeal cannot be admitted or allowed to be added subsequent to filing of an appeal unless it is proved to the satisfaction of the first appellate authority that such omission was not willful or unreasonable. Friends, this section 107 subsection 10 casts an enormous responsibility on the appellant to bring in all those allegations, to bring in all those grounds, to bring in all those issues relating to the adjudication proceedings and the issues which the adjudicating, order of the first order of the adjudicating authority suffers from. So any grounds which is not specified in the grounds of appeal will give the power to the first appellate authority to reject the additional grounds which the appellant tries to assail at the time of appeal proceedings or in the course of hearing. Section 107 subsection 10 speaks about additional grounds that appellant would want to assail in the course of appeal proceedings after having filed the appeal memo. But the issue actually lies in the grounds where such grounds has not been furnished before the adjudicating authority, which could have been furnished by the appellant at the time of adjudication proceedings. So the question here arises is the grounds which could have been taken before the adjudicating authority by the appellant and which has not been taken by the appellant before the adjudicating authority, can such grounds be taken or contested or can form part of the grounds of appeal before the first appellate authority? In this regard, we have few judgments where it says that any additional ground, even if not raised before the adjudicating authority, can be raised before the first appellate authority. Honorable Supreme Court in the Jute Corporation of India has held that the grounds not taken before the adjudicating authority can be taken before the first appellate authority. First appellate authority has all the powers to entertain such new grounds. In the case of Ramdev Tobacco Company, it is also held that a pure question of law can be entertained at appellate stage even if not raised before lower court. In case of National Thermal Power Corporation, it is held that the tribunal is confined only to issues arising out of the appeal before the commissioner takes too narrow a view of the power of appellate authority. So the in my considered view, any grounds which is not forming part of the adjudication proceedings can be taken before the first appellate authority. However, the challenge lies as to the preparation of the appeal, because Section 107 subsection 10 restricts to add any additional grounds not specified in the grounds of appeal. First appellate authority permitted to conduct such further inquiry as may be necessary. First appellate authority should be just and should pass a proper order confirming, modifying or annulling the decision. So here the scope of the first appellate authority is very limited. He has to rely upon the grounds of appeal and the order against which the appellant has preferred an appeal. When we pay an attention to Section 107 subsection 11, we can see that the power of the first appellate authority is to only confirm, modify or annul the decision of the adjudicating authority. So in the same breath, it can be understood that the first appellate authority does not have a power to enhance the liability that has been already decided by the adjudicating authority. Confirming, modifying or annulling are the words of rank which follows the meaning of the first word. So first appellate authority can confirm, he can uphold the order of the adjudicating authority, or he can slightly modify in the based on the legality or correctness of the order, based on the illegality or incorrectness of the order by the adjudicating authority, or he can annul the decision of the adjudicating authority. So Section 107 subsection 11 provides the power to the first appellate authority. It may also be noted that the Section 107 subsection 11 uses the word inquiry, which necessarily should not mean to convey that the powers of the first appellate authority in a way that the first appellate authority can re-adjudicate the matters which are neither forming part of the order nor the grounds of appeal. Few aspects in this connection are worth discussing are as follows. FAA cannot enhance the adjudication by considering the issues which were not considered by the adjudicating authority either expressly or by necessary implications. We'll take an example. there is an appeal that has been filed against the order denying the input tax credit under section 17 subsection 5. So now the appellate authority has to only decide whether such input tax credit which is denied by the adjudicating authority is eligible or ineligible based on the grounds of appeal assailed by the appellant. It is not open for the first appellate authority to hold that the input tax credit denied is an eligible input tax credit and later on take some other grounds to disallow such input tax credit, say for example under section 16.2 or section 16.4. So the first appellate authority has to decide only the eligibility of the input tax credit. Another example in this case would be first appellate authority cannot enhance the adjudication on the issues which is not at all considered by the adjudicating authority or raised by the taxpayer. An illustration in this regard would be the order is if the adjudicating the order of the adjudicating authority is denying the exemption claimed by the taxpayer without considering the fact that the taxpayer has claimed the input tax credit. First appellate authority, while can set aside the order and allow the exemption, but cannot consider the eligibility to claim the input tax credit in the course of appeal proceedings and subsequently deny the input tax credit by allowing the exemption. First appellate authority cannot consider the evidences which were also part of the adjudication and reappreciate such evidences to reach a different conclusion. However, such conclusion of the adjudicating authority can be set aside if the facts were not considered appropriately and also based on the additional evidences that the taxpayer has introduced in the course of appeal. Friends, confirming, modifying, and annulling the decision necessarily should be in line with the order of the adjudicating authority and should be based on the prayers that the taxpayer has sought in the appeal for relief. It may be noted that first appellate authority is not conferred with the jurisdiction to be the proper officer under section 73 or 74 and cannot travel beyond the order of the adjudication and the grounds of appeal. We also are aware of the proviso to section 107 subsection 11, which specifies that the first appellate authority, if is of the opinion that any tax has not been paid or short paid or erroneously refunded, can raise such an issue in the course of appeal proceedings by way of giving a notice to the appellant. Friends, even under such a proviso to section 107 subsection 11, the first appellate authority cannot travel beyond the grounds of appeal or the order. Consider few examples with respect to this proviso to section 107 subsection 11, where it's what the first appellate authority can do is this limited scope that has been granted under proviso to section 107 subsection 11. Take an illustration where there is a dispute in the classification of goods or services. The first appellate authority, based on the appropriate classification, may issue the show cause notice to the appellant proposing to confirm the tax liability on such appropriate classification. Take another example where the place of supply is disputed. The first appellate authority, willing to uphold the order or the tax liability of the adjudicating authority, can issue the notice to the appellant proposing or giving the notice to the appellant to ascertain the appropriate place of supply based on the documents that are available in the appeal proceedings or the adjudication proceedings. So these are the few examples and illustrations and the discussions pertaining to the section provision specified under section 107 subsection 11. Any questions on these, on the points or the provisions discussed so far, we can discuss it. Any issues or anything that I have missed to add or any clarity that is required on the points so far discussed, we can discuss.
Now, Kuber.
Yeah, Vinay.
Yeah, so see 107.11, are you saying that there cannot be no additional demand?
There cannot be no additional demand for the reason that section 107(11) again gives the power to the first appellate authority either to confirm, modify, or annul the decision of the adjudicating authority. To appreciate this, I mean, these phrases, let us pay attention to section 108, subsection 1, where the revisional authority has given the power to enhance the liability that has already been decided by the adjudicating authority. So since section 107 does not specify that a first appellate authority can enhance the liability, keeping in mind section 108 subsection 1, we can reasonably conclude that the first appellate authority does not have power to enhance the liability. However, the department has its own understanding saying that they are taking the route of proviso to section 107 subsection 11 and they are deciding the issues. We have few instances where they are deciding the issues which are not decided or which are not even considered by the adjudicating authority.
So modification doesn't include enhancement.
Yes.
Okay. So the ITC disallowance can increase the additional liability?
ITC disallowance cannot. The understanding is that first appellate authority has no powers to travel beyond the order. So if that particular issue is forming part of an order, and if there is certain input tax credit that has already been disallowed in the order issued by the adjudicating authority, the first appellate authority either uphold such a disallowance or to some extent modify based on the grounds assailed by the appellant.
When you said to some extent?
Considering if I furnish new evidences to prove that the input tax credit on which the input tax credit claimed by the appellant, the said goods and services have been received by the appellant. Consider an example. The adjudicating authority has disallowed the input tax credit on the grounds that the appellant has not received the goods. But at the time of appeal, in the course of appeal proceedings, if the appellant furnishes the evidences to justify that the goods were actually received, the first appellate authority can consider, subject to the satisfaction of and verification of such additional evidences, he can consider to allow the input tax credit.
That means he's setting aside the original order. So this wouldn't be tantamount to modification, no?
He can set aside the powers has been vested with the first appellate authority to set aside the order of the adjudicating authority. But there are no powers to enhance the liability and consider the grounds which are not forming part of the adjudicating order issued by the adjudicating authority.
The reason for second proviso asking the appellate authority to issue an additional show cause notice?
The powers under proviso to section 107 subsection 11 has a limited scope. In my understanding, wherever the appellate authority is trying to rectify the defects or trying to fill in the gaps, what the adjudicating authority has left in the adjudication proceedings, which is affecting the rights of the appellant, in such a scenario, the first appellate authority can invoke proviso to section 107 subsection 11 and may issue a show cause notice.
So it is more to do correct the original show cause notice. Is that what you feel?
That is my understanding.
Okay. Thank you.
Any other questions? So, as we discussed, order of adjudication is at large before the first appellate authority, and first appellate authority has to pass a speaking order within 1 year from the date of filing. So to move on, we'll discuss about the admission of appeals. Appeal preferred must be grounds involving question of law or question of fact. APL 1 should state facts clearly, whether such facts have been accepted by the adjudicating authority or disputed, or such facts have been substituted to arrive at the different conclusion. The pleadings and the grounds of allegations or evidence should form part of the APL 1. The pleading should be clearly specified what relief has been sought, relief prayed, finding on facts or identification of relevant law or application of law to facts. So when there is an order by the adjudicating authority, there can be 4 scenarios which comes to my mind. The first scenario would be there is disputed facts and there is a disputed tax also, the first category. Disputed facts but undisputed tax, undisputed facts but disputed tax, undisputed facts and undisputed tax. So let us discuss about these 4 categories of appeal. What we mean by disputed facts. So disputed facts is the when we say that the facts are disputed, the adjudicating authority has considered certain facts and arrived at the conclusion which are not falling in line with the facts. So adjudicating authority has not considered the facts appropriately. When the facts are disputed, it is obvious that the tax levied on such incorrect facts are also disputed. The cause for such situation would be on account of the taxpayer not furnishing the facts or the taxpayer furnishing the facts incorrectly. Adjudicating authority has not considered the facts furnished, or adjudicating authority has considered the facts but has reached to a conclusion in deviation with the self-assessment tax. The self-assessment of taxes under section 59. So few illustration in this regard would be, consider a case where the refund is rejected on export of services by holding that the services provided by the appellant will not qualify as an export of services but an intermediary services. Here the first appellate authority is substituting the facts with the evidences available and is reaching to a conclusion that the appellant has not exported the goods but has in fact supplied the services which are in the nature of intermediary. Consider another example. Adjudicating authority very often would deny the exemption on certain facts. We have a few practical issues with respect to this disputed facts. Would be a case where they deny the exemption to an appellant or the taxpayer who satisfies all the conditions that has been specified under the law. Consider a taxpayer who is into providing the services of Ayurveda, yoga and naturopathy. So here the law grants an exemption to a clinical establishment which provides a healthcare services. Such a taxpayer has satisfied all the conditions to prove that he is a clinical establishment, he is operating a clinical establishment, and he is also providing the healthcare services. But looking at the infrastructural facilities and other facilities that are being extended to the customers, the adjudicating authority is of the view that this will not qualify as a clinical establishment and therefore is not eligible for exemption. So the certain practical cases where the adjudicating authority is relying on the reviews written by the customers or the manner in which the bookings are done by the taxpayer who is a clinical establishment are being considered to deny the exemption. In such a case, in such a scenario, the facts based on which the evidences based on which the facts are being concluded are disputed. So the first category would be disputed facts and disputed tax. Friends, we all know that the order of the adjudicating authority should be speaking should furnish the findings, should furnish the grounds for rejecting the self-assessment of taxes under Section 59. And the adjudicating authority has the enormous, what I can say, burden of proof to discharge, to reach to a conclusion and to decide a case. If any of these things are missing in the order, such things should form part of the grounds of appeal, and to say that the facts are disputed and therefore the tax arising on account of disputed facts are also disputed. Consider another example where input tax credit is denied on the grounds that such inward supplies are not used in the course or furtherance of business. The authorities may simply deny the input tax credit with one line finding that certain inward supplies cannot be construed to be used in the course or furtherance of business. So the amount of ITC, in this case, the amount of input tax, the amount is admitted, but the eligibility of input tax credit is disputed. So these are few of the examples where the facts are disputed and the tax is also disputed. Now moving on to the cases where the facts remains undisputed, but the tax is disputed. So under this category, there may involve certain issues where the adjudicating authority has subscribed to the facts of the taxpayer. However, the tax liability as ascertained by the authority is not the tax liability as ascertained by the taxpayer on self-assessment basis. This may involve issues relating to valuation, time of supply, and place of supply. Consider a few examples. We know adjudicating authority generally tend to reject the contracts and also the evidences or all the documents that has been furnished at the time of adjudication proceedings. We have come across the situations where two different supplies, supply of goods and supply of services, having a separate contract has been rejected, and such different contracts have been clubbed to decide on the tax liability on the appellant. So this would be the classic example to say that the facts are disputed. Consider another example where the tax liability is confirmed on the goods and on job work basis by the appellant. The tax on account of delay in receiving the goods, delay in receiving back the goods beyond 1 year is confirmed. Instead, is confirmed after the lapse of 1 year instead of confirming the month in which the goods were sent out. These are the few of the examples where we can see that the facts remains undisputed and the tax is disputed. There is another category where we can see the disputed facts and undisputed tax. So when I was preparing for this, I was thinking what could be the example that could fit into this facts which remains disputed, but the tax which remains undisputed. Consider an example where the facts are admitted by the adjudicating authority, but the tax thereon is disputed. The classic example would be the classification relating to the services. One example would be transfer of intellectual property rights. Permanent transfer of intellectual property rights is classified under self-assessment as supply of goods, whereas the adjudicating authority is holding or has held that this will not qualify as supply of goods, but it will qualify as supply of services. Now coming to the last category of the appeals, where I was mentioning that facts also remains undisputed and there is no tax that is undisputed. In the sense, undisputed facts and undisputed tax. I was thinking what could be, can we have an appeal where the facts remain undisputed and also there is no tax that is disputed? We all know that the government had announced an amnesty scheme for registration. So this could be the classic case of appeals, which can be classified where the facts are also remaining undisputed, and also there is no tax that remains undisputed. So we all know that registration was cancelled because of non-filing of the returns by the appellant, and the scheme also provided with an option to such taxpayers to approach the appellate authority and get the first order from the first appellate authority, where the original authority can undo the cancellation of registration. So these are the few of the thoughts when it comes to the facts and the tax that remains disputed in the appeal before the first appellate authority. Any questions or clarifications with respect to these points what I had discussed so far? Okay, so few pointers in with respect to the admission of appeals is taxpayer should represent that the order merits intervention by first appellate authority. That means the appellant has to say that the facts considered by the adjudicating authority are disputed or has not been considered properly. The appellant has to impress that the taxing ingredients not satisfied in the order to support demand. The allegations are not based on the evidences that has been furnished at the time of adjudication proceedings. Evidences have not been considered appropriately. The appellant has to accept or dispute and discuss the basis for having accepted or disputed the facts that has been already considered by the adjudicating authority. Grounds of appeal traceable to findings reached omitted in order of adjudication. So, friends, taxing ingredients not satisfied in the order to support demand, the grounds of appeal should mention the allegations that has been considered to confirm the tax liability against the appellant, and to prove that the mandatory elements which are required to confirm the liability are missing or remains unestablished in the order passed by the adjudicating authority. So moving on, we should bear in mind that all the appeals preferred against the order passed by the adjudicating authority cannot be admitted or accepted by the first appellate authority. There is a scope for the first appellate authority to preliminary dismiss the appeals at the threshold. Appeal liable for preliminary dismissal unless the order of adjudication is shown to be bad in law for misapplying the provisions or erroneous in comprehending the facts of the case, omits to give due consideration to material available on record, adjudicating authority is arriving at a conclusion that is impossible in law or on facts, or the order is contrary to judicial authorities and administrative instruction circulars. So what is bad in law for misapplying the provisions? The order does not establish the levy, the supply, or the value considered is incorrect or estimated, or the rate of tax that is applied to confirm the tax liability is incorrect, or the time of supply is incorrect, or the place of supply remains unestablished, or the exemption is denied. So bad in law for misapplying the provisions, considering the facts and coming to a conclusion while satisfying the mandatory elements that the adjudicating authority has to prove as to be impressed in the grounds of appeal. Erroneous in comprehending the facts of the case. Take an example where export of services considered as an intermediary services again omits to give due consideration to material available on record. Take an example where demand confirmed, rejecting demand is confirmed, rejecting delivery challans and holding that delivery challans have been erroneously issued instead of tax invoices, and therefore the tax on such transaction is liable to be paid. Arriving at a conclusion that is impossible in law or on facts, let us we all know that a classic example in this regard would be confirming the tax liability merely on the grounds that 26AS depicts certain amounts as TDS, which has not been offered to tax under 3B under self-assessment under section 59. Contrary to judicial authorities and administrative instruction circular, confirming tax allegedly on, take an example where the adjudicating authority is confirming the tax allegedly on the fiction that the holding company has supplied services to subsidiary company. We all are coming across with such cases which the adjudicating authority are considering to adjudicate the tax on the appellants or the taxpayers. Intervention. The first appellate authority can intervene with the orders of the adjudicating authority only it is proved that there is a misadjudication, there is a misinterpretation of law, there is misunderstanding of facts and misapplication of law, or misplaced use of discretion, omission that the adjudicating authority has omitted to discharge the duties, and the adjudicating authority has applied extra legislative measures in an attempt to do justice. Misadjudication, take an example, confirming tax on transaction executed for the April 2017 to June 2017. Many of the orders we are seeing that the turnover which pertains to pre-GST regime is also being considered in the course of adjudication, and the tax is being confirmed on such transactions. Misinterpretation of law, take an example where interest at the rate of 2% is being levied under erstwhile section 50 subsection 3 on ITC that is denied or disallowed. Misunderstanding of facts and misapplication of law, take an example where tax on Iwadi purchases has been levied. The Iwadi purchases which have been effected after 12th October 2017. Misplaced use of discretion. Take an example where the adjudicating authority has violated provisions of section 75 subsection 7 and has confirmed the demand of tax, interest and penalty in excess of the amount that has been specified in the show cause notice. Omission to discharge duties. Take an example where show cause notice is issued under section 73 after the lapse of time limit specified, which is 30th September 2023 for the tax period 17-18. Application of extra legislative measures in an attempt to do justice. Take an example where pre-show cause notice in Form GST DRC 1A has not been issued and only the show cause notice has been issued. So all these grounds, all these pointers should be considered in the grounds of appeal, should be represented before the first appellate authority and convince and based on which the first appellate authority can consider the admission of appeal and can consider to intervene with the order of the adjudicating authority. Few pointers on grounds of appeal could be: grievances should, while we draft the grounds of appeal, we should bear in mind that we should address the grievances, we should impress on the grievances and not the unhappiness of the outcome at the in the adjudication proceedings. Mercy grounds generally will not be entertained by the first appellate authority because he is a creature of statute and he has to follow the law and he can reject the appeal. He cannot, the first appellate authority will not be able to afford the demand or consider the grounds on mercy basis. Where two interpretations are possible, ground should be adduced based on the taxpayer's interpretation and the interpretation which has been applied at the time of self-assessment under section 59. Appeal filed to defer payment. We all know that there is a huge demand and the appellant may also admit the demand, but the appeal is being filed only to defer the payment, expecting that the government may announce certain amnesty scheme. In such a cases, the first appellate authority can reject the or dismiss the appeal at the threshold. Unless it is justified in terms of the discussion what we had in the previous slide, the first appellate authority to entertain appeal. So we have to justify that there is a certain scope for the first appellate authority to entertain appeal, and all appeals filed as a matter of statutory right is liable to be dismissed. Appeal entertained raises presumption in favor of the taxpayer in later proceeding that the adjudication order merited interference for some reason. So friends, why the first appellate authority may be inclined to reject the appeal at the time of admission would be to avoid that the appellant should not presume that the order of the adjudicating authority is bad in law and which requires an interference by the first appellate authority. Appeals are admitted when the objective criteria are fulfilled, but appeals are entertained only when the subjective criteria are shown to exist. These the slides and the content what has been displayed in the on the screen is based on the Jatin sir's book on how to address the show cause notice. So objective test for admission of the appeal would be correct form of appeal, whether the appellant has used the correct form of appeal, whether the amount has been remitted towards pre-deposit, or whether the verification is complete, whether the limitation, whether the time limit within which the appeal has to be filed has been met, whether valid APL2 is issued after satisfying that after the first appellate authority has satisfied that the limitation to file an appeal has been taken care and the pre-deposit has been remitted and the form and verification of appeal has been undertaken appropriately. Condonation, if any, within the time limit. So admission of appeal, we have objective test, we have subjective test, whether the first appellate authority can entertain the appeal or not. So mistake of facts or law, if not impressed in the grounds of appeal, the first appellate authority cannot entertain the appeal. So in the same way, if there is a misapplication of law, if there is an exercise of discretion that has been omitted, or there is an erroneous findings reached or findings reached erroneously, authority is not followed, the appellate authority can intervene and entertain the appeal.
Kuber.
Yes,
Previous line. So this subjective test, the question is after the admission of appeal, now isn't not a duty bound by the appellate authority to do a personal hearing? It's like, can he now exercise subjective test and reject the appeal?
No, we are these are the pointers for admitting the appeal.
Yeah, objective test, I understand. It is now after objective tests are fulfilled. Would it not prima facie get admitted, or even the subjective test also has to pass?
Subjective test also has to pass to intervene the order passed by the adjudicating authority.
Okay.
So if there are certain mistakes on facts which the adjudicating authority has not considered appropriately, so the grounds of appeal should impress on such mistakes. The grounds of appeal should also emphasize on misapplication that has been carried out in the adjudication proceedings. Only then the first appellate authority will intervene with the orders of the adjudicating authority.
But isn't it too subjective to say that, okay, without a measurable information, saying that, okay, it will not be entertained, because I am of the view that, okay, this classification is correct. And I gave my basis in the SCN reply, and which is not considered. The same I am carrying it to my appeal grounds.
Correct. So the understanding here is that the first appellate authority is again a creature of statute, has to safeguard the interest of the revenue is what the tendency, what the first appellate authority has in general.
No, no,
So
let
therefore,
him, I am not expecting a favorable order, but my right to not get the appeal admitted, isn't it? Because I have fulfilled all the objective tests, my correct form, time limit, deposit, everything is taken care. But he is not satisfied with the grounds that I have written, cannot be a reason for rejecting my appeal, no?
that cannot be a reason for rejecting the appeal. Those can be the grounds can be considered in the course of appeal proceedings.
Correct.
And then whether the order of the adjudicating authority needs an intervention or not is decided.
Renu,
Yes, sir.
if you may come in here, you are looking at it like a computer software. If it is in garbage is in, it should come out as a garbage also. At least something should come out if it goes in. But
Correct.
what happens is, what if you have not made any prayer? Appeal is admitted within, if appeal is filed within due date, pre-deposit is there, form is there. There is no prayer in your appeal for any specific relief. Now, the relief not sought cannot be allowed, which is why today everyone says pass such orders as may be deemed fit and proper in the facts and circumstances of the case and in the interest of justice as this appellate authority may deem fit. Why do we say this as a last prayer is that we may have not made the right prayer. There could be a prayer that the order must be set aside. There could be a prayer that a finding must be reached on such and such question and consequent order may be passed. There are subjective tests which require reading the appeal memo to find out whether at all within the appeal that is filed in the right form, the hands of the appellate authority are tied. The appellate authority's hands may be tied that he cannot now give relief that was never asked.
Right.
So in those cases, what the appellate authority may be empowered to do itself may be reduced by 90%. So that becomes a area that we will need to be aware of, that an authority will examine not just objective tests, but he will even apply subjective tests, because appellate authority is interested to wriggle out of this mess. He does not want to be the one who's trying to bell the cat. If he gets half a chance to escape and run away, he will escape and run away.
Right.
So therefore, these subjective tests have to be considered by us so as not to give him any room to rely on those subjective tests and say, therefore, I cannot give you any relief. I'll give you a small example. Appeal filed in tribunal stating that first appellate authority has dismissed the appeal within that 1 month of condonation. See, condonation he has not considered. Now, let us say that appeal filed before first appeal was after that additional 1 month. Now, in the appeal before tribunal, the question is whether is not whether the show cause notice has merit or not. The question before the tribunal is whether the first appellate authority has correctly dismissed and rejected the appeal or not. Tribunal will now examine not the merits of the case. Now, in this tribunal appeal, if the question about date of service is itself in dispute, then the tribunal will need to examine all the dates correctly first to determine whether they have power to enter into this dispute or not. So these questions will only be known after they enter into the transaction details within the appeal memo. So therefore, it is for us to present this in the appeal memo accurately. That's the only point of the subject.
Got it.
We can move on, Vino.
Yeah, Kubal, thank you.
So we discussed that extent of relief legally permissible. First appellate authority is not an adjudicating authority of higher rank. And therefore, he has to stick to the grounds of appeal and the orders. He cannot travel beyond the grounds of appeal. The first appellate authority is not a proper officer. Why he cannot travel beyond the grounds of appeal and cannot go into the adjudication proceedings is because the first appellate authority is not a proper officer under section 61, 65, 65, 73, 74, and so on. First appellate authority will not reappreciate material available on record unless it is proved otherwise. So there are certain evidences which are available in the adjudication proceedings. So those evidences cannot be taken on record in the course of appeal proceedings and reappreciate such evidences to come to a different conclusion because the adjudicating authority has already taken an opinion and the first appellate authority will tend to support the views taken by the adjudicating authority in the course of adjudication proceedings. So modifying or annulling involving enhancement of liability on registered person, first appellate authority is not competent to enhance liability by considering the materials records which was not considered by the adjudicating authority either expressly or by necessary implication, unless in the event there are any additional evidences that has been furnished by the appellant at the time in the course of appeal proceedings. Such evidences may be considered, may be allowed, may be admitted by the first appellate authority based on the provisions specified under Rule 112. First appellate authority is not competent to enhance the liability on the issues which was not at all considered by the adjudicating authority. This we have discussed. First appellate authority is not competent to dispose the appeal with directions to the adjudicating authority to canvass for enhancement of liability. This is expressly specified under section 107 subsection 11. First appellate authority cannot enhance the liability on the issue which is pending before the revisional authority under section 108 subsection 1. So few illustrations. So we discussed about this. First appellate authority scope is to stick to the grounds to consider allowing the relief. The prayer cannot be generic. In the grounds of appeal, the appellant has to ensure that he has a specific prayer claiming a specific relief that is arising out of the order of the adjudicating authority. This would lead to consider allowing the relief in terms of the grounds in pleadings if found satisfactory and relief trade compatible with the pleadings. So when the prayer is generic, the first appellate authority will fall back on the grounds and the pleadings and consider such grounds and the pleadings and conclude the appeal proceedings. So we all know this, we have discussed numerous times, that granting relief on one issue may bring windfall gains to another issue which is not in dispute due to finding of fact reached and nature of relief granted by first appellate authority. Again, we have discussed this example. First appellate authority allowing the appeal against the order of cancellation of registration would result in granting a relief to claim the input tax credit which is already lapsed. Granting relief on issue may bring adverse implication on another issue. Consider an example where first appellate authority is allowing the exemption which was rejected by the adjudicating authority, which will result in reversal of input tax rate if the appellant has claimed. Few illustrations.
Sorry.
Yeah, Bindu.
Like so, where the exemption is upheld and the computation mechanism of Rule 42 will undergo a change because because of which the liability may increase or whatever. Now, which was not at all there in the, let's say, the original order.
Yes.
So how would this be taken up?
So even in that cases, the appellate authority cannot deny the input tax credit or cannot say that a portion of input tax credit claimed by the appellant or which is allowed to the appellant by the adjudicating authorities is liable for reversal. Consider an example where the exemption is denied. The appellant or the taxpayer has claimed the input tax credit and also has claimed the exemption. Now the adjudicating authority has denied the exemption, but has not given any findings or has not decided about the eligibility to claim the input tax credit by the appellant or by the taxpayer. Now the taxpayer is before the first appellate authority with the limited ground that the exemption denied by the adjudicating authority is bad in law. So the order is not speaking about input tax credit. The grounds of appeal is only speaking about the exemption which is denied to the taxpayer, which is being challenged before the first appellate authority. The first appellate authority, if he considers the grounds of appeals and the evidences or other documents which the taxpayer furnishes in the course of appeal proceedings and allows the exemption while setting aside the order of the adjudicating authority, cannot at the same time, first appellate authority cannot at the same time go back and say that the input tax credit claimed by the taxpayer is liable for reversal.
Why so? Because isn't it consequential? Now, assuming the original order containing both certain ineligible ITC disallowed and recomputation of Rule 42-43, everything the proper officer has done. After considering disallowance of certain exemptions which I have claimed, so the officer has kind of reassessed my ITC eligibility and the tax liability. Now I have gone only for the appeal on the exemption which he has rejected. Now, had the original exemption be restored, I would have been a higher reversal of input tax credit. Given that it has been rejected, the computation of Rule 42-43 mechanism is on the lower side, which is demanded by the regular officer. Now, if the proper officer is, if the appellate authority is upholding my view that yes, it is exempt. Now, the original computation of Rule 42-43 made by the adjudicating authority is wrong.
Agreed.
Now, will the powers will not be there to the appellate authority to modify some certain portion of the order, because even the proper officer would also represent this, saying that if this being the thing, consequentially this would get impacted.
Proper officer, in my view, cannot represent if he has certain issues with respect to the order. If the department has certain issues as to the legality and correctness of the order, the department will prefer an appeal. And at the same time, coming back to the issue, what has been raised here about the disallowance of input tax rate or application of Rule 42.
Now the department cannot go for appeal. No, the
department cannot go for an appeal, but if the order is incorrect, the powers are vested under Section 108 on the revisional authority to enhance the liability or take up for the revision So when it comes to the appeal proceedings, when it comes to the first appellate authority, the first appellate authority has a limited scope only to refer to the grounds of appeal and the order and to decide the issues that has been preferred in an appeal. So when input tax credit is not forming part of the grounds of appeal, in my view, the first appellate authority cannot consider such an issue which is not forming part of the grounds of appeal and decide the case. For that, the law is specifying section 108, the provisions under, powers under section 108, where the department may, subsequent to the order of the first appellate authority, can pick up the revision and may enhance the liability or redo certain things.
Got it.
Few illustrations about the grounds and the implications during the appeal. Friends, when we are drafting grounds of appeal and when we are in the course of filing an appeal, we should identify the grounds, because the grounds, as we discussed, are important to be decided before we draft the appeal, because there are provisions under section 107 which are restricting the appellant to add certain grounds, and again it is subjected to the satisfaction of the first appellate authority to admit the new grounds, which are not forming part of the grounds of appeal. Considering all these things, care has to be taken to identify the grounds and to identify the issues which the appellant or the taxpayer is willing to challenge in an appeal before the first appellate authority. Consider the first example, when validity of notice and legality of jurisdiction is not questioned in the grounds of appeal, the implication would be that the jurisdiction no longer open to consider. Validity of notice and legality of jurisdiction is no longer open to represent before the first appellate authority. When the demand is disputed but allegation is not denied, undisputed allegation cannot be considered in appeal, and undisputed allegation will become a fact based on which the first appellate authority may continue with the appeal proceedings and dispose the appeal. Evidence in support of allegations not challenged. Consider an example, third-party statements have been relied for completing the adjudication proceedings on the appellant. So such evidence, if is not challenged in the grounds of appeal, such evidences would be considered as admitted, and this excuses the revenue to prove from burden of proof. We are admitting when such certain evidences remains unchallenged or questioned. So it infers that such evidences by the appellant, such evidences are admitted by the appellant. Facts stated in show cause notice, order not reviewed or restated. The implication would be facts admitted become final, binding, and inalienable. Then only the question of law would prevail if forming part of grounds. New material and information introduced. Conclusion from such material liable to be rejected if reliability is in doubt. If I furnish new material, consider an example where at the appeal, during the appeal, at the appeal stage, the appellant is furnishing the certificate to secure the claim of input tax credit in terms of circular number 183. The first appellate authority has all the powers to consider whether to consider or to reject such new evidences or new materials which has been presented in the course of appeal. Tax position in self-assessment explained with reasons. Demand may be sustained based on the findings by the adjudicating authority. So for all the first, the taxpayer is before the first appellate authority. For the adjudicating authority has deviated from the self-assessment of taxes undertaken by the taxpayer under section 59. If the grounds of appeal only explain the self-assessment of taxes and they use the interpretation of the self-assessment of taxes done by the taxpayer, the findings of the adjudicating authority in the order would remain undisturbed and the first appellate authority would be inclined to uphold the demand in the order passed by the adjudicating authority. Dispute raised on valuation only without disputing the levy of tax, then the levy of tax may be considered as undisputed. No dispute raised on place of supply, the appellant cannot argue on the nature of tax or nature of demand and may be considered as undisputed. When no dispute is raised on time of supply, quantification of interest cannot be argued before the first appellate authority. When the bona fides of inward supply is pleaded for credit admissibility, implications would be that failure of credit conditions accepted. Additional grounds of defense not included in pleadings. No new grounds may be allowed. We have a express provision, section 107 subsection 10, which gives the discretion on the first appellate authority to consider new grounds. Demand is confirmed under section 74, but the same is not questioned in the grounds of appeal. The implication is that the appellant is admitting to the evasion of tax. When the demand confirmed under section 74 without discussing the reliability of evidence to support special circumstances, relief under section 75(2) available and fresh inquiry into existence of special circumstances almost barred. Demand confirmed under section 63 not questioned, use of estimates and guesswork and lack of evidences to support suspicion admitted. Fatal defects, discrepancies and deficiencies in show cause notice is not questioned. First appellate authority may not be compelled to be redressed before examining the issues on merits. Grounds in order beyond grounds in SCN, shortcomings in SCN to support demand admitted. When the grounds says that the order is passed on haste, in a haste and bias manner, the implication would be that failure of adjudication is exposed. So then the first appellate authority may take up the case or to intervene with the order of the adjudicating authority. Disputed about facts in SCN not redressed or shown to be untrue. Implication is that it confirms demand to be contrary to facts. Notice was defective and yet demand was confirmed. Order may be set aside as defective. Order passed beyond applicable limitation period. Section 7510. Order passed beyond applicable limitation period 7510. In all these cases, order may be set aside as defective. So we have to pay a lot of attention as to what grounds we should take. When certain procedures has not been followed at the time of adjudication by the adjudicating authority and has concluded the adjudication proceedings without following the due processes, that needs to be paid a lot of attention, and such issues should form part of the grounds of appeal to bring on the face of the record of the appeal papers that the due process has not been followed by the adjudicating authority, and therefore the first appellate authority, and therefore it can be pleaded that the first appellate authority should consider this first appeal and set aside the order as defective. Orders which are defective result in demand being irrecoverable. Few pointers on grounds. non-speaking orders not only violate principles of fairness in adjudication, but also impose an enormous burden on appellate authority to enter into fact finding. So when there is an order which is not giving the findings and which is not giving the basis on which the based on which the order is concluded by the adjudicating authority, it imposes a burden on the first appellate authority to fill in those gaps, to fill in those facts which remains unestablished in the order by the adjudicating authority. So the first appellate authority may enter into the may consider the order of the adjudicating authority and ensure that the order or the adjudication proceedings which is being concluded by the adjudicating authority is complete by way of supplying the requisite missing things. Appeal is the only remedy when adjudication order is adverse, whether it is speaking or non-speaking. Non-speaking orders only afford additional grounds in appeal and not that can be carried back to the proper officer for adjudication afresh. Not even the first appellate authority is allowed to remand. To assail an adjudication order for being non-speaking, it is important to show that it does not provide any information as to the basis for conclusions reached and makes the ratio of adjudication unknowable. So we have discussed about the mandatory elements that needs to be considered by the adjudicating authority, and all those elements that needs to be satisfied. The levy of to uphold the levy of taxes. In the event any of those elements remains undiscussed in the adjudication order, say for example, supply or valuation or rate of tax or place of supply or time of, then such issues, such missing things, such missing mandatory elements can be considered as the grounds to prefer an appeal before the first appellate authority. Grounds of appeal should demonstrate how exactly the adjudication order is non-speaking so that first appellate authority may enter into fact finding while disposing the appeal. So we all know about this doctrine of merger. The adjudication order once intervened by the first appellate authority will become an integral part of the appellate order by the first appellate authority and the order of the first appellate authority. And the order of the adjudicating authority will merge with the appellate order of the first appellate authority. Appellate order need to be elaborate, and those grounds and findings in adjudication order that receive the support and endorsement by first appellate authority by this doctrine become order of the appellate authority. Doctrine of merger applies where any finding in the previous order receives consideration and approved expressly. This applies to rejection by first appellate authority where the grounds and findings that have been considered and rejected are deleted from the order of the appellate authority. Friends, these are the few concepts about the first appeals under the GST laws. I have collated few of the judgments which are relevant for the first appeals. So we can just pay attention to a few of such judgments. So the first issue is whether appellate authority can suo motu frame a new issue and decide the same. We discussed about this. We discussed and we concluded that okay, the first appellate authority cannot suo motu frame a new issue. Whether revenue can turn around and initiate separate proceedings on the same issue for which they are not agreed by the first appellate order, and whether the first appellate authority can remand the matter back, it is not permitted. Whether telephonic conversation for a brief period could be a substitute for a personal hearing. There is an error. Could not should be removed. Could be a substitute for a personal hearing. The answer is no, which has been held in the case of Jupiter Exports. The next case relates to not following certain procedures, like not filing the certified copy of the order. The Honorable Court has held that not filing the certified copy of the order is only a procedural requirement, which should not be considered for the rejection of the appeal. We discussed about the other issue, whether the consignee can be considered as a person aggrieved when order under section 129 is passed in the name of the truck driver. We discussed about this. Aggrieved person is the consignor or consignee who has a grievance against the order passed by the authority, and such person can prefer an appeal before the first appellate authority. These are few of the issues or concepts relating to first appeals. Hope we discussed all the issues pertaining to the first appeals. If any questions are there, or if any things or any issues or any pointers if I have missed to consider in the course of my discussion, I am happy to receive or ask the members to give their mention such missing things in my discussion.
Could be two doubts I have. One is 107 is using any decision or order. So how do we refer here? What do you mean by decision? Is it something which is defined in 108, or what do we refer here? Any examples of decision in 107? That is one thing. And because we see in 107 they have used aggrieved by any decision or order. So what can be an example of this actually?
Any decision or order, we know that the order is order passed under section 73 or 74 by the adjudicating authority. Decision or order, I would want to say that decision also refers to an order for the purpose of appeal under section 107 subsection 1.
Because in 108, they have used the word decision shall include intimation given by any officer lower in rank than the revisional authority. That is covered only for 108. So
Correct.
that is one thing I just wanted to understand.
State decision or order. So the decision by the adjudicating authority, which is coming in the order. I mean, according to me, there is no distinction between the decision or order. Or maybe we can consider an example. There is some adjudication done on certain other person. I don't think so. In my view, decision or order should be the same, madam. Any other members who can add to the question what Annapurna madam has put?
Isn't it registration notice, cancellation notice of registration is a decision? Which can
Notice cannot be the decision, no? You know? Notice cannot be the decision.
okay, suspension
Suspension will be by way of an order.
order, yeah.
Can this be the document which was seized during the search proceeding was requested to release? The authority decided not to release. Can
But
this be
when
a
we have
decision?
an express provision that seizure order cannot be challenged before the appeals.
No, not seizure order. See, it has to be returned at the specific time. Those document which is not used for show cause notice or after show cause notice has to be returned. So if the documents are not returned, so we can make an application to return. If they are decided not to give back, can that be a decision and not an order?
In my view, but there is not returning the documents cannot be said to be on the decision taken by the authorities for not returning, no?
So let's take that as an example, Mailar's example. He refuses to give you the documents. He writes a letter saying that for whatever reason, I'm not going to give you that decision, those documents back. And you need to file an appeal. Let's say you want to file an appeal. Mailar, can you tell me whether that appeal will now not be accepted? Mailar, officer says he will not give you the documents for whatever may be his reasons. Okay. And that decision you want to file an appeal. So you're saying now will that appeal be acceptable by the appellate authority?
Because they use the word decision and order, I thought.
Alala, see what is happening is we are using our deep knowledge of English language to come to a conclusion on this question of law. We have to go to administrative law to understand what is a decision or order, which is a outcome of application of mind within the due process prescribed in the law.
Okay.
Otherwise, officer applying for leave also is his decision. Then there's no end to this decision or order business. If we are aggrieved by it, there are two kinds of decisions or order, those that involve quasi-judicial functions and those that involve administrative functions. 121 very clearly lists out decisions and orders which are not appealable. So if we look at 121, we will get a direction to identify which are decisions and orders. And even though they are decisions or orders, they are held to be not appealable. So therefore, other than those, other matters don't become decisions or order for the purposes of 107(1). Now, to issue an order under 65(1) to conduct an audit, to issue an order under 151, like Venu was saying, to call for information, it is not appealable because that by itself does not cause prejudice. Somebody was even saying that they will file a writ petition questioning, how did you choose my name for audit? Then you're coming in the way of department doing its function. So I would sense that unless it is a decision or order arising out of a adjudication, quasi-judicial proceeding, it may not be something that can be carried in 107. Madam, does it provide some input
Yes.
for your question, madam?
Yes, sir. Yeah, got it, sir. And one more issue, sir, this transition credit we have applied for that new revision. They just sent a letter saying that we are not accepting your application for transition credit. So can we take that also as a decision, sir? That was also one more.
Madam?
thought. So transition credit application we have applied, and the department has just sent a letter.
Transition credit application,
ಅದು ಟೆಂಪ್ರರಿ ಬಂದಿತ್ತಿಲ್ಲ ಸರ್ 3 months ಗೆ ನೀವು ಅಮೆಂಡ್ ಮಾಡಿ ಟ್ರಾನ್ಸಿಷನಲ್ ಕ್ರೆಡಿಟ್ ಗೆ ಅಪ್ಲೈ ಮಾಡಬಹುದು ಅಂತ ಹೇಳಿ ಸೆಪ್ಟೆಂಬರ್ ಅಕ್ಟೋಬರ್ ನವೆಂಬರ್ ವಿ ರಿಸೀವ್ಡ್ ಇನ್ ದ ಲಾಸ್ಟ್ ಇಯರ್ ಸರ್ ಸೊ ವಿ ಅಪ್ಲೈಡ್ ಫಾರ್ 3 months ಅದು ವಿಂಡೋ ಓಪನ್ ಇತ್ತಿಲ್ಲ ಸರ್ ಸೊ ವಿ ಅಪ್ಲೈಡ್ ಫಾರ್ ದಟ್ then department has just sent a letter saying that you are not eligible for this we are not accepting your transition credit application ಅಂತ ಅಷ್ಟೇ ಹಾಕಿದ್ದಾರೆ it has not come through any order or anything as such so I was just looking whether we can take it as an appeal and can we take it as an
outcome? If it is an outcome of your application, then you are eligible to file appeal, manual appeal, alva?
Howdu sir, howdu. So that is what I was reading.
So I think so that is also a decision for rejecting your accepting and then passing an order of rejection is one thing. Rejecting your application at the threshold itself is worse than passing a order after accepting. So I think definitely that's a decision or order which you can carry in appeal.
Correct, sir. Because if we see that pre-deposit, sir, they have used only order. They have not used the decision in that 107 subsection 6. They are using pre-deposit of order only. It means the decision may not have the quantification and order will have.
I don't think I don't think it is that extent of
difference.
Correct, because what happens is, if you see, we have to understand the difference between a decree and a judgment. Let's say there's a civil suit or a criminal complaint, decree and a judgment. Now, suppose there's a partition of joint family property. The judgment will say who should get what share of which building, who should get business, all of that is the judgment part of it. Decree is the final one sentence. Okay, Annapurna Kabra will get 100 acres in Bangalore. So you are now, if you are holding the judgment, you will have nothing to execute. A decree holder only can execute. So judgment contains the reasons for the decision or decree. Okay. Similarly, an order contains the conclusion of a decision taken.
Okay.
Therefore, I sanction refund of 1 crore. That is the order. The operative part of the decision will be in the shape of an order. That is why reference in 107(6) is only to order, because that is where the amount is quantified. Rest of it is all 16(4), 16(2)(a), bona fide, indefeasible right, vested right, all that is in the decision part of it.
Yes, sir. Yes, sir. And any of us have received a notice, sir, under 10711, sir, because I have not experienced this.
I
Specific.
have come across one instance where a notice was being discussed as a draft in the department.
Okay, okay,
The
okay.
instance there was
Hmm.
officer has issued show cause notice on tobacco products. He
Hmm.
has levied 28% tax on tobacco product, saying that tobacco product is involved in this, is supplied. Under he has confirmed the demand. Party has carried the matter in appeal. The appellate authority was contemplating to issue a opportunity to the appellant under 10711 proviso, saying that if it is a tobacco product, then cess of 72% has to be
Hmm.
paid.
Hmm. Okay.
See, because here they're not changing the grounds. Everything is same, except that the incompleteness is completed. So that is the limited extent I would tend to think that show cause notice 10711 can, because there's this is the operative part, isn't it?
Yes, sir.
So therefore, that is the only portion I can think of
Okay, sir.
where they can enhance.
But the most issue is the time limit specified in 73, sir. That is also
Of course.
challenging.
Even this has to keep that time limit in mind, because by the
Yes,
time
sir.
it goes to appeal,
Yeah.
it should not have crossed the 73-74 time
Correct.
limit. So therefore,
Yes.
those things anyway have to be considered. But this is the only instance I can think of.
Yes. Okay, sir. Thanks.
Sir, if section 74 application is challenged, now suo motu the penalty in 73 will happen, or the fresh order under 73 to be issued?
No. The appellate authority will decide that it is not fit under 74.
Right.
So consequently, as per circular 185, the computation of the tax, interest and penalty payable will have to now be made under 73. So APL 4 to be issued by tribunal, by a proper officer after tribunal's order, or APL 4 issued by appellate authority will now compute as if the notice was always under 73.
Okay, if the original notice of 74 is well within the time, then okay. Assuming if that is not well within the time of 73, sir.
So that's what circular 185 says. That portion which has crossed 73 time limit has to be eliminated, and the balance only computed and APL 4 issued.
Okay.
With regard to 10711, it uses the words inquiry over there. But we always say that once the show cause notice is issued, it is culmination of investigation proceedings and commencement of adjudication. But in what context is this inquiry used? And what can we have it as an example of what appellate authority can do in this process of inquiries?
I see, like Kuber said, that the appellate authority is not adjudicating authority of higher rank, but appellate authority has inherent powers to ensure that facts are refined and recorded in a reliable manner for further proceedings. So to do so, the word inquiry is used so that he has investigative powers limited to what is material available on the file. I'll give two examples. There is an appeal that we were appearing for before First Appellate Authority. The assessee is a GTA. Assessee is a GTA. The demand of tax is that revenue in books is not matching with revenue in 3B. All his services are B2C. So therefore, he's been paying 5% tax. Officer says you have not paid output tax on the difference of revenue between books and 3B, and he has demanded 18% tax. So, usual short reply was given, and adverse order suffered in adjudication, carried in appeal. Appellate authority said, yes. Yenri logical, if you're a GTA, how he can demand 18%, 5% irbekalva. was his question. So therefore, the question was whether appellate authority can confirm 5%. So I said, so you're saying, you give me the books and books of accounts, I will do the enquiry because I'm a fact-finding authority. I have power to find out what should be the facts. I will go into all of these things. So I told him that we will not give the books. He was a little bit offended. To give a hypothetical, to continue that argument there, hypothetically what we said is, sir, suppose I tell you that the difference of income is from sale of shares. What can you do? If I say the difference of turnover was from sale of immovable property, what can you do? If I say it is sale of trucks, what can you do? Can you impose 28%? Therefore, you have to allow me not to give you any new material. Officer got upset, etc. But if you see here, the power of inquiry is not coextensive with power under 65. Power of inquiry exists, but it is confined to the scope of the proceedings, material available on record in the adjudication order, and not beyond that. Limited to the order in question, whatever inquiry is necessary can be done to ensure the facts are correctly collected. Second example is, on other income, a tax was demanded at 18%. The nature of other income was discounts allowed by suppliers. So in appeal, we said that if discounts are allowed by suppliers, you should raise a demand for reversal of ITC and not demand output tax. So the Joint Commission Appeal said, okay, I will drop the demand for output tax. I will confirm the demand of ITC. And then she discovered that under 107(11), she can't do that. Although the quantum was lesser, it amounted to a fresh notice. So therefore, she was in an awkward situation as to how to proceed further. So this power of inquiry, therefore, is not coextensive with 65 or 67 or 61. The power of inquiry is limited to material available on record in the impugned order.
Thank you, sir. Sir, but in section 70, again, the word used is inquiry I. Here also words used is inquiry I. I mean, should it be read from that context, or it is to be contextually equated to e-inquiry?
No. Don't change the word to suit your convenience. But the word inquiry is investigation. But investigation within the purview of the material that they have jurisdiction to look into. 67, they have wider coverage. 107, they have limited. Don't change inquiry to enquiry. It is still inquiry. They can issue summons, they can call for expert witness, they can call for certificates to be issued to establish reliability of facts, but don't change the word. It is investigation, but within the confines of the impugned order.
Okay, sir. I mean, can we have any thumb rule as to how to identify?
The context should help you identify the scope of power.
Okay, sir. Okay.
Jatin sir.
Sir.
In fact,
America idira?
Illa sir. Bangalore sir.
Background alli eno ide. Vidhan Soudha white color. Heli sir.
Sir, yesterday I happened to be in department for some case appearing for hearing. Actually, coincidentally, the officer was discussing with the other officer about this refund and this thing. So one of the officer was telling this officer, sir, refund sanction madidare. ಈಗ ನೀವು refund process ಮಾಡುವಾಗ you will find that certain credits are ineligible. So ಅದಕ್ಕೆ separate show cause notice ಏನು ಮಾಡಂಗಿಲ್ಲ. Order ಅಲ್ಲೇನೆ ನೀವು you can demand that whatever the excess ITC availed, because circular 125 says RFD 8 is read with section 73-74. Hence, we need not issue one more show cause notice for that ineligible credit to be recovered. I was just trying to say how they are misunderstanding that particular provision and going wrong, and that will help the assessee, because the time limit to issue a notice for a irregular availment of credit would lapse.
Correct. But actually, notice to issue show cause notice for irregular availment of credit is longer than the notice for recovery of erroneous refund.
Correct.
So
The
you're right.
date of refund in the three
Correct.
years.
You're right.
I mean,
You're right, sir. You're right.
whereas here, the annual return. So,
Correct.
but they were mixing up and they want to issue that revised DRC 07 with additional demand which is not there in the show cause notice. They were telling even the show cause notice we can confirm that in the order. So that I'm bringing to the attention of the members that like this, there are a lot of misunderstanding as Jatin sir said. We can, in fact, some of the officers said, we are adjudicating authorities. Once the order, principle of merger prakara, now we are the adjudicating authorities and we can do anything and everything which was not done by the adjudicating authority, which is again not, in my view, also not possible. One more observation, the first point which Kuber was mentioning of service of notice vis-a-vis a communication of notice. If we see that provision dealing with the service of order, in fact, subsection 2 and 3, there's a deeming fiction created. Where if we carefully go through the individual mode of communications under section 169, if I'm not wrong. So there, if you see that talks about, it doesn't cover this electronic mode of communications. So the deeming fiction of a service notice, unless evidence is brought out, cannot be said to be a communicated is one possible argument which we can take in the wherever there is a delay which is happening, because mail would have been sent, portal would have been uploaded, but I have not seen, I have not opened at all. So that whether it can be treated as a communicated is something where it is a matter which is going on discussion. So I thought I'll just bring to that notice. If you see section 169, service of notice in circumstances, in subclauses it talks about A is about the tendering, and B by a post, C and D by a email and a common portal, E by publication newspaper, F by that is affixing. If you see subsection 2, it talks about the tendering, publication or affixing, and whereas subsection 3 talks about a registered post or speed post. If you see 2 and 3, the clause C and D relating to email and common portal, the deeming fiction is not available. So I am interpreting that though that mode of service is available from the department perspective, for the purpose of appeal, I should have been communicated unless the evidence is there of having received. These two, subsection 2 and 3 will come into picture. Jatin sir, you have any view on that?
I'm with you on this, sir.
Yeah, okay. That is one more thing, and I think Kuber covered various scenarios and the points, I think, which we have been practicing for many years, at least from my side. I think probably all of them are coined together for the benefit of members. Sai Prasad, Zara?
Illa, sir.
Okay.
Sir, one more issue we are having, sir, is regarding this rectification when we are filing on few of the issues in the order. If they're not passing within that appeal period, I think we are just preparing the appeal and paying the 10% also, sir. So
Correct.
so that is what is happening, sir, actually. So actually they should give that time limit, sir, further for that filing appeal. There should be some section, sir.
Sir, that is, sir, that is also a decision, no, sir, when they are not, when they are issuing endorsement, not accepting the application and not rectifying the order.
So it is a decision under 161 of the officer. This is not a decision under any other section, alva. So therefore, it may be a concern. that they may not see in rectification, they cannot reappreciate all the evidence and redo what they have already done, rightly or wrongly.
Sir, in VAT we tried, sir. It happened, but I don't know in GST.
So,
In
no,
VAT
madam, the
we-
illegalities of VAT are corrected in GST.
Yes.
We have to leave the time. Order is time barred. Sometime later, we will file rectification, do some adjustment with officer. After 1 month, he will pass some order giving some very small amount of relief. Now the dead order has come to life, and you file appeal to tribunal against it. ಇದೆಲ್ಲ ದೊಡ್ಡವರುಗಳು ಮಾಡಿ ಹೋಗಿದ್ದಾರೆ, ಅದನ್ನ ರಿಪೇರಿ ಮಾಡಕ್ಕೆ GST ಇದೆ. We should not bring back all the perverse practices of VAT, madam.
No, no, only my point was, sir, there we had 5 years. Here anyway, time limit is 3 months only, sir, in GST. So that has been corrected. But the thing is, if we don't get rectified order within that specified time, we end up paying that pre-deposit of 10% on that amount which you have applied for rectification. So that is also a huge impact, sir. So that is what I thought. If they would have bring some provision in 107 regarding this, I think it will help. That
No, then
was-
what happens is all orders will go in for rectification.
Okay.
Just to get now we will get 4 months to file appeal. With this, you would have got 7 months to file appeals. No justice would have been done.
Okay. Okay.
100% of cases we will file rectification application. ಏನಕ್ಕೆ? Just to get 3 more months.
Okay.
That would be unfair for those who did not file rectification. Alva.
Yes, yes.
Now rectification will become the standard route before going to 107.
Anyway, we can file the appeal and I think we can add that ground, sir. And later on it can get.
Correct. Rectification also has not been considered.
Yeah.
See, but actually, rectification can be very useful to prevent tribunal from remanding. File a rectification and say that, look, and he does not give a conclusion, does not correct it, or he does not entertain that application. Tomorrow, nobody can say, but you should have asked him. Why didn't you ask him? I have an order from First Appellate Authority that says the original authority has not applied his mind. He has not come to the demand correctly. That is in the discussion part of the order. The operative part, finally, the party's appeal is hereby dismissed.
Okay.
So now we have to go on further appeal. Tomorrow, tribunal should not say, okay, I will remand it back to the First Appellate Authority to pass operative part of the order. So we filed rectification application. He said, no, I will not rectify. Everything is as per law. So that now we will get relief if the tribunal finds favor with our grounds.
Okay.
So rectification application can be a matter of great strategy.
Yes, sir.
Sir,
Hello.
Sir, this rectification issue which are there, just wanted to share a thought. We have to be a bit careful. Assuming we are disputing on, we are going to dispute on four issues, and we have applied for rectification of only one issue, and we have not applied for rectification of other 3 issues. So the time limit for filing the appeal for other 3 issues will not be will not get merged with the other rectification which I have applied. So can I file an appeal on other 3 issues and still wait for this rectification to be disposed?
So very valid point, and the answer also you know.
So I have to, that is the
Only
precaution.
leggy you cannot admit in hospital. Full patient you have to admit in hospital.
So I'm stuck here. If rectification is not disposed of, sir, within the time limit for preferring an appeal, then I take a ground that rectification has not been considered also along with the other 3 issues.
It may not even be a ground. It may be a statement in the statement of facts to say, I have filed rectification and before limitation under 107(1), the application has not been disposed of. So therefore, your grounds may be considered on their own merit. So I think that's, I agree with your approach.
Any other points, questions from anyone?
What Rajesh sir was saying on 169.2, deviation from the topic, but since he had explained it, so what does he mean is that only what is tendered or published is an order, and the time limit for others, what will be the time limit for others then, if it is served through other mode?
ಏನಪ್ಪ question?
169.2 says decision or order which is tendered or published.
So other decisions which are prepared and kept in the file,
Huh.
what
Which
is the
is not
decision?
tendered or
Example ಕೊಡು.
published.
Give an example where they come to a decision and keep it in the file.
They've emailed it. They have not tendered or published.
ಇಲ್ಲಪ್ಪ. All the ways of, if there is a duty to communicate it to the counterparty, the mode may be any of the 14 ways in 169, but it is communicated, tendered. Whether it is accepted by the received properly by the person or not is where the point Rajesh was making. I leave it for Rajesh to comment on this, but all decisions that have an inherent requirement to be communicated to the counterparty come within the operation of 169. Ilva?
I didn't get what Rajesh sir was making the point that.
No. Sir, Rajesh sir, idara. Mute.
Rajesh sir.
Sorry, I missed. I had gone out. Heli Venu, sorry.
Sir, the point is Deepak is asking,
Sir.
decision or order which is communicated to the party, the point you explained under 169 is understood. What if there is a decision that is reached but not communicated to the party? Then will this apply? Deepak, correct me if I understood, if I didn't state your question properly.
Yeah, okay. Sir, reached in the sense, what is reaching? Reaching vis-a-vis the communication, the portal, it has reached, but the purpose and intention of the using of the word communication in the appeal provision as against service in other places in the statute, I should become aware to file an appeal. If I have not been aware at all, how can I file appeal? So it has come and sitting in the portal. It has come in the mail. I have not even opened and seen it. Then the fact that it is not communicated can be, so it cannot be deemed that they have served, but I can always claim that I have not seen. If I am able to file a sufficient document evidence that I have, or to say that, I have not at all opened the mail is inoperative, the mail was being not being used regularly, it is an auditor's mail ID which is given, portal I have not logged in for so many days. So those can be the basis to say that I have not, it would have been delivered to my email ID, it might have been uploaded in the portal, but it is not yet communicated to me as a person, is what is my stand on that.
And Deepak, see, in all fairness, the idea is not to just tick one box that it was sent. The idea is to do justice, not only in the adjudication order, but also in ensuring that the party is now informed about the conclusion, decision reached, so that he can avail the remedies available in the law. It will show bad faith on the part of the department if they select the least expeditious way to reach the order to the party. See, I have an example. This person he supplies the sweepers to BBMP. Okay, his turnover is 100 crores. He supplies sweepers to BBMP. He is also uneducated. Sweepers are uneducated. His customer is highly uneducated. Everybody is uneducated. They use mobile phone only to see video. Yeah, video? Ade, when smile martaralla, ade video. Now, how can you assume that a highly sophisticated portal service mode is a reasonable choice of mode to reach the notice to this party? If you are IT company, Every day you're opening e-portal, every day you're opening your email can be assumed. But this BBMP sweeping contractor, how can you assume that he will open his email ID, and how can you assume that this is the best way to send him a notice? It shows bad faith on the part of department that they did not also send it by RPAD. Send it by registered post, call him, say, give it to, send a bill collector to deliver it, take acknowledgement. Simply you cannot tick the box that it was sent by uploading it on the portal without due consideration to the background of each assessee.
Difficult to make this statement, no, sir. Practical, unpractical to implement.
Sir, I actually very simple from an assessee point of view. If assessee takes a stand that I did not get it, now the department has to show that it is not just accident, it is gross negligence on the part of the assessee. Not to have done everything possible to ensure daily he has to keep monitoring like ICU doctor. That is not the requirement also. And if you weigh date of service versus the substantive remedies that the party will lose if this is not entertained, I think, Deepak, it will do you good if you read section 5 and section 14 of Limitation Act and read the judgments under both of those, section 5 and section 14 of Limitation Act 1963. Any good book on limitation you please take and read the commentary. 5 is a right, 14 is a remedy. So there, sorry, 14 is a right, 5 is a remedy, and there are a number of judgments to deal with. What is one judgment I can think of is Isha Bhattacharjee versus State of Maharashtra, where the Supreme Court has given 14 justification for what is sufficient cause. What is the meaning of sufficient cause? There are 14 justification points given by Supreme Court. So therefore, Rajesh point is on very, very strong footing.
Yes, sir.
Correct. So that your example, what you're giving, that will not be limited to such instances. So it could apply to all instances because there's no discriminative words in this subsection 2.
No. So facts and circumstances will differentiate the correctness of the choice of mode.
Okay.
The facts and circumstances itself will show. See, if you are a dealer registered in Chalakere, if you are a dealer registered in Yadgir, then the choice of mode cannot be the same as a dealer registered in Electronic City. The facts itself make them, differentiate them substantially.
Okay. So a dealer who is in a city cannot take this case that I have not received it over email.
Now again, you're trying to make it like
Answer.
software. In a city, in pin code number so and so, MG road idre, you cannot take a reason outside MG road. It is not like that. It is facts and circumstances. See, we must allow some elbow room, some play at the joints must be allowed for the uniqueness of the facts in each case to be given due consideration to arrive at a conclusion.
Okay.
City is possible, village is not possible. It may not be possible to say something like that. Examine the facts, come to a conclusion, but this point is not something to be dismissed lightly. I have seen many instances where appeal has been filed by somebody stating date of service. What's that, column number 7 in APL1, date of service as the date of the order itself, without realizing that date of service is not the date of order. In fact, this was one of the requests sent to GSTN saying that there should be 2 different columns, date of order, date of communication of order in the online version of APL1 because it is auto-populating. Date of order, date of service is getting auto-populated. There should be one field to be entered, and difference between date of order and date of communication order, if it is more than 3 or 4 months, there must be an affidavit with COD application, justification, all of those things will come into question. There are there are a
Yes, sir.
lot of amendments still to be made to this section 107. And the rules also. Already one set of amendments have been made in 108. More amendments are required. You see how things will develop as we go along. In sir, yellow color kai. Congress.
Sir,
You should change it to flower, sir.
I will figure out, sir. I'll do that.
Because the color and the hand shape is not matching.
Okay. Sir, in case of manual appeals, after the appeal is filed, if the order gets uploaded online, do we need to file an again online appeal and ask for merging both the things, or how?
ದೇವರಿಗೆ ಗೊತ್ತು ಸರ್ ಇದು ಏನ್ ಮಾಡೋದು ಗೊತ್ತಿಲ್ಲ. ಆಫ್ಟರ್ ಆನ್ಲೈನ್ ಅಪೀಲ್ ಕಲೆಕ್ಟ್ ಫೀಸ್ ಅಷ್ಟೇ.
This has actually practically happened. We did nothing so far because the appeal is there.
ಅಷ್ಟೇ don't file one more manual ಅಲ್ಲ ಸರ್.
Yeah. Okay, sir.
ಸರಿ ಸರ್.
That's all, sir.
Okay, thank you.
Yeah. Thank you, Kuber. Thank you, everyone.
Thank you, Jatin sir. Thank you, Siddesh. Thank you, Rajesh sir.
Thank you, everybody.
Thank you, sir.
Thank you.
Thank you so much.